This case was about the estate of John Payne from East London, who died in 2012 at the age of 74. He had 4 children with his first wife. After leaving her, he married Kim Payne soon afterwards. They had no children. At the center of the case was John Payne Jr., one of John's sons, and John Payne's wife Kim. After John Sr.'s death, John Jr. produced one will and Kim produced another. This led to an epic battle of wills that would run for many years, going all the way up to the Court of Appeal. At stake was an estate worth around £600,000. Not surprisingly, the will produced by John Jr. left the bulk of the estate to him, while that produced by Kim the widow left everything to her. The bad feelings between the two ran deep, and the police had to be involved at one stage with a restraining order for harassment being issued, and this threatened to spill over into another criminal case. Which will would be upheld? The 2012 will produced by John Jr., which was dated just a few months before his father died, and supposedly witnessed by his girlfriend and her mother. Or the 1998 will produced by Kim and made a few years after her marriage to John Payne. The protagonists in this case were John Payne, the son of the deceased, and Kim Payne, the second wife and widow of the deceased. The battle was over 2 wills that were supposedly made by the deceased John Payne Sr. The will that was put forward by John was made in April 2012, just a few months before John Sr.'s death in August. That will left just £15,000 to Kim. There was another gift of £15,000 to John Jr.'s son, but the rest of the estate went to John, cutting out his siblings. The will was typed up but was not professionally made. The witnesses were John Jr.'s girlfriend and her mother. Kim presented an earlier will made in 1988 shortly after her marriage to John Sr. This will, made on a printed form, gave everything to Kim. There was a dotted line for John Sr. where he signed his signature. But when it came to the witnesses, there was no separate space for each witness to put their signature after writing their names. So the 2 witnesses put their names on the document, but there were no separate signatures in the sense in which we commonly know it. There was a history of bad feelings between John Jr. and Kim. There were allegations of forgery, with the matter being reported to the police. The police investigated but did not press charges. John Jr. brought civil claims against Kim, but they were all thrown out. Things came to a head with a restraint order for harassment being issued against John Jr. Eventually, the case reached the court. First, there was the will presented by John Jr. Remember, that was the will witnessed by John Jr.'s girlfriend and her mother. The judge was unhappy with their evidence. Now, there's a legal rule that if the will says that the witnesses were present when the person signed the will, then it is taken to be so. But if the judge doesn't accept the evidence of the witnesses, then that rule goes completely out of the window. The judge found the evidence of John's girlfriend and her mother to be utterly unreliable. She said the legal presumption that the will was properly signed had been displaced by the manifest untrustworthiness of the witnesses. On that basis, she ruled that she could not say that John Sr. knew of the will or its content. That will could not be admitted to probate and was thrown out. Then there was the 1998 will put forward by Kim. The main problem, though, was that the witnesses did not sign the will. They only wrote their names. In addition, she did not ask them to give evidence. If she had done so, they could have given evidence that even though they didn't put their signatures on the will, they were present when John Sr. signed, and they wrote their names in his presence. The judge felt that there was inadequate evidence to find that the will had been signed as required by law. The judge decided against both wills, meaning that John Sr. would be said to have died intestate. That means without a valid will. Both parties were unhappy with the judgment. They both tried to appeal, but John was refused permission to appeal. That meant that the 2012 will was now dead in the water. Kim was given permission to appeal against the judgment regarding the 1998 will. The question for the Court of Appeal was whether the will was valid, given that the witnesses only wrote their names but did not sign the will. Kim also wanted to rectify some of the things that counted against her in the lower court. She wanted to be able to produce the original will and also to call Mr. Gordon and Mr. Hodgwood, who were the witnesses to the will. She wanted them to come and give evidence to the court. So how would she fare in the Court of Appeal? Would the lack of signatures from the witnesses invalidate the will? Would she be allowed to get the witnesses to come to court to give evidence? Also, what would the appeal judges make of her failure to produce the original will? So would she fail at the second hurdle, or would she be thrown a lifeline? Find out after this short message.
Is your family being ripped apart by an inheritance dispute? Are you about to squander your inheritance on legal fees? Wait! Why not try mediation instead? It's a great way to resolve inheritance disputes. You get a result that works for you, and you rebuild family relationships. Plus, you save thousands of pounds on legal fees. Best of all, it only takes a day, so you save months and years of litigation. Mediation saves money, saves time, and heals family rifts. No one loses, and everyone's a winner. Go to remyayela.com/inheritance-disputes to get started today. Online mediation is available.
Kim was able to produce the original will at the Court of Appeal. In addition, she managed to get Mr. Gordon, one of the witnesses to the will, to come forward and give evidence to the court. She had tried to get both witnesses but was unable to reach Mr. Hodgwood. The Court of Appeal said it had no hesitation in accepting Mr. Gordon's evidence. John Jr. had tried to argue that the court could not come to a decision without hearing from both witnesses. But the court rejected his argument, saying there was no requirement that both witnesses to the will had to give evidence in court. They were satisfied with the evidence of just one of the witnesses. 1. On the face of it, the will appeared to be validly executed. The fact that the witnesses wrote their names rather than signed their names does not matter. There is no requirement in law for witnesses to sign their name in the modern sense of the word. They just need to write their names with the intention of attesting to the fact that the testator signed the will in their presence and they in his. The Court of Appeal said that the judge in the lower court came to her decision without having seen the original will, especially since it was clear from the photocopies submitted to the court that the full text had not been reproduced in court. The judge should have appreciated that the issue could not be resolved without producing the 1998 will itself and without hearing evidence from at least one of the attesting witnesses. Yes, this would have necessitated an adjournment, but there are occasions of which this was one when an adjournment is the price to be paid for justice to be done. 3. The Court of Appeal said that the judge had refused to adjourn the trial to allow Kim to get written evidence from the witnesses to the will just because it was a bit late in the proceedings. In refusing to do so, the judge had failed to take into account whether it was in the interest of justice to do so. The Court of Appeal decided that there was a strong public interest in valid wills being upheld. The Court of Appeal would not be willing to pass over an apparently valid will without any evidence that it was invalid. The court concluded that the will would be pronounced to be valid, and John Jr. was warned that he had no choice but to accept the decision of the court, as the decision could not be changed. He must accept that this was the true last will and testament of his father. This case clears up an important question of whether the witnesses need to sign the will or not. The Court of Appeal accepted that they don't have to sign, and it's enough for them just to write their name, as long as they did so intending to be witnesses to the signing of the will by the testator. However, I do recommend a belt and braces approach, rather than having to come to court to battle it out. Therefore, I suggest that as well as writing their names, your witnesses to your will should also sign their signatures. That way, it leaves no room for argument later on. Join me again next time for another fascinating Battle of Wills.